first, I have a very important question. I must ask you. Which one of you sharks will join me and take Beardhead to create the perfect storm of success? Sample time now.
All right.
Here we go.
Thank you, David.
This one is going to be for you.
Oh my.
Get that one.
How do you?
And Barbara.
Velcro.
Cheap that.
All the beards are detachable.
Thank God.
No cash flow for you. Whoa!
Very nice.
David,
guys.
I love it. I think
Thank
it's
you.
a great idea, but let me ask you
Appreciate
this.
it. Sure.
Haven't I seen this before?
We do have competitors, yeah.
Okay. So
Lots
why
of
are you different than the other ones?
Well, for one, I want to just point out, we came out January 2009. We didn't start seeing copycats and imitators until about 12 or 18 months after that.
You're
but they
the
do
first
exist.
to do this?
Yes.
But there's no way to protect it.
It is not utility patentable.
Tell us about your numbers, David.
Absolutely. We've sold to date 250,000 beard heads, $5 million in sales.
This year.
No, total.
So
Since
they
we
sell
began.
for 20 bucks a piece typically?
Typically 25 to 30.
How much have you sold in the last year?
Sales last year, 936,000, which was an anomaly for us. We had a down year. The prior year to that was 1.3 million and 1 million.
But also, maybe
before
it
that.
means it's slowing.
It could.
Santa doesn't like that.
So he mentioned patents there, right? And he had some competition early on. I want to touch on that. He said actually very specifically that he didn't think that the beard head itself was utility patent protectable. Let's take a timeout right there. There's a difference between utility and design patents. And there is a reason I'm going to get to later as to why this founder knows so much about patent law. So a utility patent protects what something does. And in this case, this beard head, its overall utility is actually entertainment. Okay. It does have an underlying, of course, warmth factor. If you're out in the elements, you will gain the benefit of having a head covering and be protected from the cold. But it also has that additional sort of novelty aspect where its marketplace movement is entertainment. Yeah, it's right. It's sort of a costume. And so it can provide enough to get a utility patent, but you've got to be able to provide evidence that it's novel and non-obvious. So its novelty, even though it is a novelty item, likely was not novel enough to get a general utility patent on that benefit. Okay. Headscarves, head wearing, clothing is really challenging to get a utility patent on. It'd have to be quite narrow and might not be worth the while in getting that application through the process. So what is protectable? Design patents, right? He said specifically utility patents. So there are design patents out there. And guess what? Beardhead was not the first to protect it. So Beardhead got in some trouble. In about 2014, they were sued by a company called Beardo. They owned a patent that was issued in 2013 on a very similar product. Let's have a peek at that patent. All right, we'll share the whole window here. So, and I'll make this a little larger. In 2013, they called it a combined ski face mask and hat. And it was originally filed in 2011 and took until October 2013 to get granted. But it's a design patent, because it's a D right there. Okay. The assignee is Beardo Incorporated. Different, of course, from the company we just looked at, which is Beardface Incorporated. So the owner of this patent filed their one claim for a design patent. It's just a single claim, the ornamental design for a combined ski face mask and hat. And so you can see they've got, looks like maybe hook and loop or Velcro attachments to a hoodie that have different types of fabric, perhaps. But what's interesting about designs is it doesn't lock you in to a specific type of fabric. It's just the ornamental appearance. So it's a three-dimensional shape. This could have any type of a color or look, okay, on this type of material. But as long as it has this shape, they're going to be protected. And so if we look at the website over at Beardo, that's exactly what they've got, right? They've got different, beard hats where the knitting is there, right? They've got long. Now, this one here, particularly the Viking beard hat, this likely would not be protected under that one design patent. But one like this would, right? It's got the overall shape, even though it's got, a heavy knit. That is going to be irrelevant. They're still going to be protected on that front. So what they do in 2013, they brought a lawsuit. In 2014, Stat Ltd versus Beardhead. And without dragging you through the entirety of this case, what happened was Beardhead got in trouble, and now they have to pay a license to Beardo in order to sell every product that they are. Every single one has to get a certain percentage sent back over to that design patent holder. Huge win for Beardo, right? Now, they weren't necessarily the first to market, but they were the first to file the patent application, and they had a unique enough idea that they were able to get it through to the examination and get the patent granted. So, very interesting case here, and that's probably why Beardface, the one that pitched to the Sharks, didn't get a deal, because their margins were additionally cut by that original design owner. So let's take a peek here. I want to showcase one of our other clients that we have in the beard space. This is Cut Buddy, and Joshua Esnard is a client of ours, proud client. We've had him on our show before. He's got a different type of a product. You can see the Cut Buddy, who actually was on Shark Tank several times, got funded by Damon John, and it's a very simple product. I mean, a lot of our inventors, prospective inventors, some people that I speak with when I'm at networking events, they're like, "Oh, I'm not an inventor. I have these cool ideas here and there." It doesn't have to be, this wild software, or electronics, or detailed, involved, groundbreaking invention. It can be hardware, right? A simple piece of plastic, while certainly innovative, is enough, right? Can be market shaking and can make quite a bit of revenue over the time. So this is available on their own website, and it's on Amazon as well. And I know for a fact that Joshua and his team have got into a licensing deal with Andis, who you've probably seen on the shelves at Walmart and some of those other big box stores. So congrats to Joshua and his company for solving some problems for people with beards. And so what this product does, as you can probably see, helps you line it up and cut your beard appropriately. So it gives you that perfect shape so you can trim your beard and have it not be so bushy like mine is getting to. So congrats to Joshua on that. So we'll take a few more minutes here, and we'll open it up for additional questions from anyone from our audience, from the live audience. And then we'll look to wrap up soon. Again, I was hoping that my co-host Matt Kulseth would be here to join me, but he's tied up today. So we'll have to catch with him next week. And we might do a follow-up to see a deeper dive into that case, because there were some interesting issues that came up. I wasn't able to get to them before we went live today. But what they did is when Beardo, right, sued for design patent infringement, wisely, okay, Beardface countersued for trademark and trade dress infringement. Now, that's going to be something we'll talk about next week if we want to keep on going on this theme of Movember, which I think we should. So trade dress is really a form of trademark protection, but it covers a lot like what a design patent can. One of a good example for a trade dress is Coca-Cola, right? Their distinctive shape of bottle, okay? That shape is covered under trade dress. And how similar, right? It's very similar in terms of what it protects as a design patent. A design patent comes with more rigor with respect to it having to be novel, first of its kind in the world, and non-obvious. But a design patent, a trade dress protection really is more generic and covers more about the brand and what the trademark has been able to be distinctive in the marketplace. So Matt Kulseth and I will talk more about that case, trademark and trade dress, next week. So on behalf of Bold Patents and myself here, JD Hoovener, I wish you guys a great rest of your week. We'll see you here next week, Wednesday at 1:30 Pacific. Have a good day, everybody. Go big, go bold.